Hello everyone, today I want to talk about a situation that is pretty interesting to see happen. We've talked about this concept in the past a few times, but when it comes to the ability for an individual or a group of people to sue a firearms manufacturer because of the actions taken by a private individual using one of their products, that's in the headlines today, and a lot worse than just the potential, like with New York talking about how they wanted to allow it to happen. Today we have a judge that ruled that Smith and Wesson is going to be potentially able to be sued because of what someone did with one of their firearms. Before we get going though, I do want to say thank you to everyone that supports this channel. Every like is very much appreciated. No sponsor on today's video, but if you want to support the channel, you can use one of the affiliate links down below. So today we're talking about a shooting that happened in California, and this is why it's a little bit particular why I'm covering it in specific. We've seen in the past where several other states have allowed lawsuits to go forward or to proceed to the next level when a firearms manufacturer made a firearm and then someone else decided to use that firearm in an unlawful act. But this specific one is in California. I'm going to read a few snippets from this Washington Post article. The title of it is Synagogue Shooting Victims Can Sue Gunmaker Smith & Wesson, California Judge Rules. Now, the survivors and families of victims of a shooting at a California synagogue in 2019 may proceed with a lawsuit filed against the manufacturer of the weapon used in the attack, as well as the gun store that sold it after a ruling issued by a San Diego judge last week. This is pretty interesting because I use this reference every single time we talk about suing a firearms manufacturer because what someone did with one of their guns. We don't sue Toyota every time someone drunk drives a Prius into a crowd or accidentally hit and runs someone. But apparently, according to Biden, Obama, Hillary, and every other liberal or left-leaning talking head, the firearms industry is the only industry that is protected when someone misuses one of their products. Now, there's a very big difference between someone making a faulty product that then hurts someone or someone making an illegal product and then it causing damage or injury. That's very different than Smith & Wesson making a firearm which is and was legal in the state of California, and then someone buying that legal firearm and then using it. The particular reason why this one is so crazy and why it shows the bias of this judge so heavily is because of this. San Diego County Superior Court Judge Kenneth J. Metal dismissed manufacturer Smith & Wesson's assertion that the lawsuit was barred under a law that protects gun makers from some liability when their products are used for crimes. In a ruling released Wednesday, Metal said that the lawsuit demonstrated sufficient negligence on the part of Smith & Wesson in marketing the gun. You heard it here, folks. The way that they marketed the gun was negligent. What did they market the gun as? Accurate, reliable, dependable, that it shoots bullets? How could you possibly market something that is a gun negligently? They're not saying, hey, Smith & Wesson, the choice of violent extremists everywhere. That's not what they're saying, but apparently he thinks it is. Metal said the lawsuit demonstrated sufficient negligence on the part of Smith & Wesson in marketing the gun and an assault-style semi-automatic rifle that can be modified to fire fully automatically. Yes, because the firearm can be modified to be made full auto, it is being allowed to be sued for that. Now, keep in mind the ATF has certain characteristic traits they would look to as far as whether or not something can be made full auto easily, which is why we had a whole situation with the Tommy built TG36 or the T36 where the ATF said, that can be modified too easily or it's too readily convertible to be full auto. These laws are completely arbitrary, completely ridiculous, and any person with the machine shop or gunsmithing knowledge could easily make any firearm that is semi-auto full auto with enough time. So this idea of having them be readily convertible, apart from it being fully assembled, fully completed, fully made, fully auto, I think that it's a completely ridiculous definition to draw because either it's full auto or you have to modify the firearm to become full auto. So I don't really know how they determine it, and to be honest, it seems like the ATF doesn't either. But this judge is saying that it is possible, so therefore they were negligent and they can be sued. Keep in mind, as of right now, I'm not aware of any actual knowledge of this firearm having been converted to fully automatic, which, even if it was, What does it matter as far as Smith and Wesson? Because ultimately that's not something that they marketed. They're not saying, hey, this gun can be easily converted to full auto, wink, wink, nudge, nudge. I don't think anyone's manufacturing it in that means, because if they were, the ATF would likely step in and consider it full auto if it was actually readily convertible. The lawsuit says Smith & Wesson designed the M&P15 similar to the popular AR-15 semi-automatic rifle so it could be easily modified to fire fully automatically. This sentence I think I have the most difficulty with, because the M&P15 is just an AR-15 style firearm. AR-15 stands for Armalite Rifle Model 15, which is a very specific model and configuration. So when we say AR-15, it's kind of like saying truck. Like if I were to say I drive a truck, you would assume that I drive some kind of vehicle that has 4 wheels, potentially more if it's a semi-truck. But a truck, you typically think of 4 wheels. It's got a bed, it's got a cab, and it's got a certain shape, right? That's what an AR-15 style firearm, it's kind of a similar thing. Whereas the M&P15 is just Smith & Wesson's version of an AR-15. So yeah, and can it be easily modified to fire fully automatic? Like, you can buy things that can do that, but the gun itself would require drilling and then special parts that are not the easiest to get a hold of. And the ATF is saying that it can't because they're allowing these firearms to be sold. So if these were readily convertible, like this judge is claiming, the ATF would have had an issue with it already, which they don't, meaning that it isn't, right? Again, these laws shouldn't be in existence in the first place, but we're just talking about what's going on with this specific lawsuit. The lawsuit also says the company used marketing on social media and in advertising through video game-like commercials, despite the known risks that young people in that demographic are highly susceptible to that type of advertising and have disproportionately perpetuated mass shootings using similar firearms. Okay, this is definitely one of the judges, this is definitely one of the people that would have blamed Modern Warfare 2 for every violent event that's occurred in the last 11 years since it came out. Video games are not the problem, the guns are not calling their name. Me having a firearm in the background here it's not whispering to me, do a bad thing, do a violence. It doesn't work that way. They are advertising these firearms to people who want to have a reliable, accurate, dependable, affordable firearm that can be used for hunting, self-defense, defense against a tyrannical government, target shooting, bump firing into trash if you're an AK guy that wants to buy an AR-15. There's a wide variety of owning these firearms. Maybe it's collector value. That's how they market these things. And they're not saying Smith & Wesson, the choice of violent extremists everywhere. In addition to naming Smith & Wesson, the ruling says San Diego Guns, the store where Ernest purchased the rifle, can now be sued by the plaintiffs. Ernest was 19 at the time of the shooting and did not have a hunting license, exempting him from California's minimum age of 21 for owning long guns such as the M&P15. This is interesting because in California, for those of you that are unaware, and you were under the age of 21, so you were 18 to 20, if you wanted to buy a rifle or a shotgun, you would have had to have a hunting license or be maybe a police officer. There were some other exemptions, but generally you would have to be 18 to 20 with a hunting license to buy a rifle or a shotgun. So if they did, in fact, illegally sell him the firearm, they might have some ground to stand on here. I don't agree with that law in general, and there are some challenges to that going forward already. And keep in mind, the FPC is currently one of the organizations challenging California's age-based ban, so that would potentially come into effect here. I'm curious to see how that specific part with San Diego Guns selling them the gun unlawfully is going to play out. It is something to keep note, because if this sets a standard of how they can actually get by it because of the marketing being too tactical, that's going to be pretty interesting, especially when we see it having happened multiple times in multiple states. That could be huge. Wrongful death suits for large numbers of people dying. Now, if they do that every single time someone dies from a firearm, to every manufacturer, I think there's a lot to be said about that, and there's a lot to potentially be aware of, and let's not stop the fight here. If you guys have any questions, comments, anything, drop it down below. You guys know the drill. Have fun, be safe, stay dangerous. Peace.